and all that. Welcome to the February 21st, 2024 special meeting of the Planning and Zoning Commission. We're going to get some legal training on quasi-judicial proceedings and special use permits. Do we need to do a roll call?
I guess we can, just for posterity.
Roll call.
Chair Levi.
Present.
Vice Chair Barton.
Present.
Commissioner Wheatley.
Present.
Our newest commissioner is it Sickle? Cycle. Present. And Commissioner Reed.
Present.
Have a quorum, though we don't necessarily need one for tonight's meeting.
All right.
And we're televising
Yep,
this.
we're streaming, recording live, so folks can watch afterwards. You can't be here tonight to be on the same page with you all. So.
Much appreciated. Yeah, so Miss Ashley, what do you have?
Okay. Well, good evening, commissioners. And we are doing this training because in January of this year, we made an ordinance change so that the Planning and Zoning Commission will be the final deciding body on special use permits. And under North Carolina law, special use permits must be decided according to quasi-judicial procedures. And quasi-judicial procedures are different than legislative procedures, which what you usually do on conditional zonings or rezoning, when you can take in whatever evidence, it's not very formalized, versus a quasi-judicial procedure, which is much more formalized, where you can only consider the evidence that's brought before you that evening. You cannot discuss it outside of the meeting. And so it is, some training is involved. So I'm going to walk through the basics of it this evening. I just got a lot of information into your folders. There are articles from the School of Government. You have all the statutes in there that are related to SUPs and quasi-judicial procedures that I'm going to be discussing tonight. There's a copy of the adopted special use permit ordinance that has not been codified yet. So when we do a text amendment, it takes a while for our American Legal Publishing to get it into the code. So if somebody's trying to look online to get that section of the code, it's not updated. So that's why I've got the approved ordinance in your folder. We also have, I have an excerpt from this excellent book on quasi-judicial procedures from the School of Government. And we have this, we've handed this out before, but I think we have a couple of copies available too, if you'd like to borrow these. But I included the chapter on special use permits for your information. There's also some information. The city of Raleigh provides a pamphlet for citizens and for commissioners on what a quasi-judicial procedure is. And probably at some point, I will want to talk to the chair about whether this is something we should do, because it's a learning process, not just for the board, but for the people who come to speak. Because unlike other procedures, there's limits to who is able to present evidence at a quasi-judicial hearing. So with that, I will begin. Let's see. This is taken from our ordinance. A special use is defined as are uses which are generally compatible with other land uses permitted in a zoning district, but which, because of their unique characteristics or potential impacts of the surrounding neighborhood or the city as a whole, require individual consideration of their location, design, configuration, and/or operation at the particular location proposed. So we have the uses that require this special use permit listed. Sometimes you'll see these as uses by right in another section, but when they are in certain districts, they are uses that have to have this special use procedure. So I don't have them all listed because I couldn't fit them. I think there's 3 that are missing, but these are the most common, and these are in our chapter 716-2. So the special uses are historic landmark special use, telecommunications towers, telecommunication towers concealed, adult establishments, ancillary non-residential uses in residential districts, detention centers or jails, government buildings and uses, group homes, drive-through facilities. I will say that the city has not had a request for a special use permit in probably about 6 years. They don't always come up very often, but we decided to retain this section of our code rather than just getting rid of it when we were doing the 160D changes, because they do come up every once in a while, and we thought this was the best process for these kinds of uses to be determined, the decisions about them to be determined. And as luck would have it, we do have a couple of special use applications in the pipeline, so we have to get this training going now.
May I ask, so Clay helped us with a new table of uses in the UDO, and so that table also has like a footnote for the S. Is that part of this as well?
That's kind of confusing because S is actually stands for uses under special requirements, which is different than SUP. So SUPs used to be called CUPs.
Yes.
And they're denoted on the table of uses by a C. We did not change that.
Okay,
So where you
good
see
to know.
S, it
Thank
doesn't stand for SUP, but where you see C, it stands for SUP.
Okay.
It does say that in the key if you get confused. Just kind of go to the bottom of the table and it'll tell you that, but it's very nonsensical.
Yeah, and as part of the amendment, we did add the asterisk, even though it was the best way to do it, because as you know, that was a 30-page ordinance amendment, just because there were so many places that special use permit, conditional use permit had to be changed to special use permit. Okay. So again, under North Carolina law, special use permits must be determined by a quasi-judicial procedure. And the way to think about it is quasi-judicial. So think of a courtroom. There are a lot of standards that have to be followed. There's lots of procedures to be followed, but it's not the same as going to a court. It's quasi-judicial. So there's some flexibility. But basically, you as a body are looking at the law, looking at the standards, which we have in our ordinance, and determining, hearing the facts presented by the applicant and perhaps parties that have standing, which I'll explain. And then those standards, you're applying the standards or the application to see how it meets the standards. A quasi-judicial decision is not one where you're discussing whether that should be the standard or not. It's not one that's based on public opinion. Sometimes you'll get people that just come up and say, I don't like that use. You're used to hearing that in a legislative decision, and you can consider that. But in a quasi-judicial decision, if, say, a neighbor comes forward and says, I really just don't like it, that's not competent evidence. And we'll go into that some more. So again, a quasi-judicial decision has to be based on, and you'll see this over and over, competent, substantial material evidence. It's really all about due process. This is a final decision, and it's based on standards, and if someone is turned down for an application, their next option is to appeal to the court. So you really want to ensure that due process has occurred, and due process is giving somebody an opportunity to be heard, to have fair and impartial decision makers, to have evidence that's presented at the hearing, not something that's discussed somewhere outside of the hearing. And again, here we go again, competent material, substantial evidence it's what's trustworthy, what's related to the standards, and sufficient to support a conclusion. And all of these things are what the board will need to determine. Additionally, in order to have a fair and impartial decision makers, the statutes lay out what commissioners' conduct is required. You can't have a fixed opinion. That just means that you can't come into a hearing thinking, I know all about, you might see, you don't know all the evidence, but you might see just something on an agenda and say, nobody's going to change my mind about whether that's should be, allowed to be there or not. You have to be open to the evidence that's coming before you. You can't have a conflict of interest, which we'll go into the details of that more. And you can't have any ex parte communication, which again means you can't be discussing this outside of the actual hearing. As an attorney, I would be guiding you, but just like other times when there might be a conflict of interest, or if you have an ex parte communication, you would state it so that everybody knows, my neighbor came up to me, they started to talk about it, I said, I can't discuss this, but I wanted to let everybody know, you disclose it to the rest of the commission, and then I would say, can you still make a fair and impartial decision? And then usually that's enough. But it is very different than what you might be used to, again, in a legislative hearing where you can talk to your neighbor, or you might have a phone call, or a developer might call you. That's just not going to be allowed in a quasi-judicial procedure. This is one of the hardest parts about quasi-judicial procedures, this participation by interested parties. We term it that way so it's not so legalistic, but the statutes really say only the people who have standing can testify. And I will go over an introductory preamble that the chair usually reads about quasi-judicial procedures, just to help people in the audience to understand that it's a public hearing, but that doesn't mean that everybody has the right to speak. You're only supposed to be giving evidence if you have standing. And we'll go into that more. But generally, the way we explain it to the public is if you are an interested party and you want to provide testimony, and we use that word testimony so they realize this isn't just me saying, I don't know, I don't like this. And also, what they testify to shouldn't be based on personal preference or opinion. It always needs to relate to the standards that the commission is trying to ascertain will be met. Evidence that will be presented to you comes in different forms. The basic evidence is your application. And you haven't had a chance to see one of the applications, but the way we write it, and we'll be going over the standards. Where are the standards? I thought I had them already. But the standards are written, there's 7 standards. They're in chapter 7:16(2) of our ordinance. And all of them must be found to be met in order for you to approve a decision. So in the application, we put the standards and we ask the applicant to state how they meet the standards. And I'll talk about it later, but the initial burden of proof is on the applicant. In general, good testimony is going to be sworn. That's a requirement under the statute, sworn or affirmed. It has to be fact, not opinion. It's got to be focused on the standards. It has to be supported by firsthand knowledge. It can't be unsworn. So say somebody comes late to the meeting and they come up to I want to speak. it's going to be usually the chair or somebody on the commission saying, have you been sworn, just to be sure. Or, and then often people will be talking and you might hear them stating opinions and they might need to be reminded, can you state what you're saying and apply the standards? And remind them that you are limited in only considering whether it meets those standards or not. Opinion evidence is not allowed when there's a decision regarding property values or projected traffic impacts or other technical matters, which might be something like stormwater or engineering requirements. And then overall, outside evidence should never be weighed as heavily as the evidence that's being presented before you at the hearing. So sometimes you'll have a neighbor come and speak, maybe they're the next door neighbor, and they'll say, my other next door neighbor couldn't be here, but I have a written statement from them. Because it's quasi-judicial and not a courtroom, you can accept that evidence, but you just would not want to give it as much weight as something that's actually being presented where you can ask questions of that witness. So that's something that I often have to remind boards as we go along. You know what? I'm really sorry because I want to talk about the standards and I'm not seeing.
I've got them pulled up if you want.
Oh, I must have missed it. I did miss it, and I'm so sorry. I'm just going to stop. It was, sorry. In the order of things, it was after I mentioned the special uses. These are the standards, and these are the standards that are in our ordinance. So the standards you'll have to use to base your decisions on. And I'm sorry, they're kind of tiny, but I was trying to get all 7 on one page. But the standards that we use are, 1, the proposed use or development of the land will not materially endanger the public safety or health, that the proposed use or development of the land is reasonably compatible with significant natural topographic features on the site and within the immediate vicinity of the site, given the proposed site design and any mitigation techniques or measures proposed by the applicant. 3, that the proposed use or development of the land will not substantially injure the value of adjoining or abutting property. 4, the proposed use or development of the land will be in harmony with the scale, bulk, coverage, density, and character of the area or neighborhood in which it is located. 5, that the proposed use or development of the land will generally conform with the comprehensive plan, smart growth policies, sustainable economic development strategic plan, sorry, I misspelled that, and other official plans adopted by the city. That the proposed use is appropriately located with respect to transportation facilities, water supply, fire, infrastructure, and that the proposed use will not cause undue traffic congestion or create a traffic hazard. If the applicant demonstrates, and I'll go into the level of evidence they have to present, if they demonstrate all of these, you must approve the application. So now I'll skip ahead because we've talked about, we're at evidence, and this is really where it comes in. As we just said, opinion evidence. This is one that we'll have to pay attention to because your standards do have, there's a standard related to property value. So the applicant would have to provide evidence that the use they propose does not diminish the value of the adjacent properties. It's a hard one for people to understand because sometimes a property owner says, well, they don't want to go out and get an appraisal. You don't have to have that. They can testify about the value of their own property. They can say, I know my own property has had a certain value, But that might not be considered adequate. It's going to be up to the board. And somebody might stand up from the neighborhood and says, well, everybody knows that a use like that's going to destroy my property values. That's definitely not admissible. So that's one that comes into play. The projected traffic impacts needs expert witness. So it would be like a traffic engineer. But you know from legislative hearings, a lot of times people say, well, you know, the traffic impact is going to be. Now, they can testify according to current situations they may have witnessed. So they might not be able to say, I think this is going to generate this future impact. But they could say, I live across the street, and I have seen an accident every day there for the past, month, or something like that. And if they can really say, and then somebody else stands up and says, oh, I've witnessed that too, that can be accepted. So that could help you a little bit. But if it's about something that hasn't happened yet, that's not going to be evidence that you can take into consideration. Okay. Standing, as I said, is another one that's difficult because people are used to just speaking at meetings. And it's tricky because, well, of the other quasi-judicial procedures at the city, one is variances that are held by the Board of Adjustment. Hardly ever do they have, it's somebody, a property owner, asking to have maybe more of a, usually it's less of a buffer or something like that. And hardly ever do they have some opposing party coming forward. And the same for Historic Resources Commission. Their standards are based on a lot of architectural standards, and usually the only people that oppose those are the next door neighbor. They have standing. But basically the only people that have standing are the owners of the property, or if they have another ownership interest, so a leasehold interest in the property, or they have a contract to purchase the property. That's usually going to be the applicant saying they want to do something. Those who have standing to oppose it are those that are going to have a special harm from that use. And it's very difficult if you're just in the neighborhood to say you have a special harm. Usually it's only the adjacent property owners that can come forward and say, I can demonstrate that I'll have a special harm from this. So the way it plays out normally is you hope that the opponents have a lawyer and that the applicant has a lawyer so that they can cross-examine and you guys can sit back and say, I'm not going to determine standing. Let's see, how this plays out. Because if no one objects and say it goes forward, and as long as you've only considered, maybe you didn't even rest your decision on a witness that didn't have standing. But it's not going to be turned away at court because if somebody, say the applicant just represented themselves and they didn't object. It's not our job to tell them, you have to object. But if it goes to court, they have lost their opportunity to object. So it goes to court. So it doesn't usually happen. I'll try to guide you as best I can. If it's like, again, you just want to try to ask somebody, can you tell me how you're an interested party? Can you tell me how you might suffer special harm? And just try to, because the board can ask questions of any of the witnesses to try to help you determine whether you should really be considering their testimony or not. The burden of proof is also difficult sometimes. It's generally the applicant bears the burden, and as I said, in the application, they're supposed to be saying why they think they meet the standards. Also in the application, we'll have staff commenting on how the standards are met, if it's something that's sort of clear in the ordinance. But But staff is not going to comment on things like traffic and property values. That's up to the applicant. Now, after the applicant presents their evidence, its burden shifts to opponents to say, oh no, that's not sufficient evidence. And there were 2 cases. I said we haven't had a special use permit in 6 years because we lost the last one under PHG v. City of Asheville. We call it the last hotel case because it was quasi-judicial at City Council. City Council didn't often hear those. They handled it quasi-judicially, but they gave a lot of weight to testimony from somebody who was not an expert on traffic, who simply came forward and said, I live near there and I think that traffic's going to be terrible, as opposed to PhD who had a traffic study. And a lot of it turned on that. And so that case, and then, which is 2020, and then a case afterwards, dismissed in 2022, started to say, maybe we're requiring too much of applicants. We don't want to go overboard with what they have to prove. So all they have to prove is just a little more than and they use this word, that's why I quote it, scintilla of evidence. So the applicant needs to just say, look, if it is traffic, they probably should have an expert opinion. But on the other things, which as you know from the standards are fairly general, they just have to sort of make the case. They don't have to prove it. They have to give enough evidence. So the applicant must produce this competent, material, substantial evidence tending to show that the use meets the standards, but they don't have to prove that it meets the standards. And once the applicant's met that burden, the burden shifts to the opponents. If no evidence is presented to counter the applicant's evidence, the applicant is entitled, and this comes from the case law, entitled to the permit. And the local government lacks the authority to deny it. Those 2 cases really kind of turned quasi-judicial procedures on their head. They shifted the burden really, even though the burden's still on the applicant, it's fairly low burden and a much higher burden to challenge it. I know this is a lot of information. The last slides are really just going over the statutes and highlighting words I've already been describing to you. So I'm just going to go through them and then we can stop for questions. So these are the statutes that are related to quasi-judicial procedures and special use permits. 160D 406, quasi-judicial procedure is required for special use permit. It's the one that lays out how these quasi-judicial procedures go. You have to have the evidence, the people have to have standing. There has to be competent material and substantial evidence. The board is going to administer an oath. We've never filed a class 1 misdemeanor against anybody for falsely testifying, but we could, I guess. And the decision shall be, the decision will be based on that material evidence that comes before you at the hearing.
Can we go back to the oath?
What is the swearing?
Is the oath just?
Swearing an oath and possible Bible and what's going on here?
Is it just you swear to tell the truth, the whole truth?
Absolutely.
Okay.
Yeah, and we have that in the preamble, and the chair becomes responsible for saying anybody who wants to speak at this hearing, who plans to testify, needs to come forward, and no, it doesn't have to be on the Bible, because a lot of you swear or affirm. We always say swear or affirm, but people raise their right hand and say, do you swear to tell the truth, the whole truth, and nothing but the swear or affirm, and that's it. And so, and if somebody isn't sworn in, their testimony, as I said earlier, is not a valid testimony. It can't be considered.
So and that would include the applicant has to be sworn in.
The applicant and the staff, not the board, not the attorney. So, but I'm not going to be making the case, but the staff has a staff report, and they will be speaking to certain of those standards. The applicant will, and then often it's somebody who's going to contest it or a neighbor that's going to speak. And that, again, is going to, we'll just get through it, but it's it's hard for a neighbor who's used to speaking to say, what do you mean I have to swear all of a sudden? And we'll just have to do our best to try to say that we do this. I advise Historic Resources Commission, and as I said, I try to write the preamble so it's not so legalistic. And so we just sort of say, if you want to speak, you're going to have to go through this process.
Another question, you said not the attorney, but I'm assuming the applicant's attorney is probably also going to be helping make the case, so wouldn't they need
Attorneys don't need to swear or affirm,
because they just already have?
because they're under ethical obligation to tell the truth, the whole truth, and nothing but the truth. But,
Janice, you do the swearing in all at once, though, right?
yes. So for you, you're usually going to have one matter at a time. And that's why we put it to the front of the agenda, so we can say this is a quasi-judicial procedure, and on this matter, if anybody's getting up to speak, we ask everybody to stand. And they used to come up front, but they kind of do come forward, and they swear or affirm. And that's why, and then sometimes people on the HRC, they'll come in a little late, and we know that they haven't stood up. And so when they come up, you say, I'm sorry, we're going to have to swear you in. Yeah. It's part of the process. I know again, it's quasi-judicial. Any more questions about that? Okay. As I said, because you're supposed to be fair and impartial decision makers, you can't have a conflict of interest. Under 160D 109, this is how they define conflict of interest. You can't have a fixed opinion. You can't have ex parte communication. You can't have close familial or business or other associational relationship to the applicant. And you can't have a financial interest in the outcome. If you do, then that's one of those things you'd recuse yourself. Or if it's one of those, somebody mentioned this to me, but it didn't affect me, I stopped them before they could get their point out, then that's again the kind of thing that you would disclose to the rest of the board. And sometimes the rest of the board has to determine, I don't think you can, having heard that, I don't think you could make a fair and impartial decision, so we'd like you to recuse yourself. That happens sometimes, not very often. 160D 705 is where it specifically says this is a quasi-judicial zoning decision. Says you will follow quasi-judicial procedures, and for special use permits, it does lay out that there are conditions that can be added, but they have to be reasonable, and they can't be conditions for which the local government doesn't have authority under statute to regulate. In some applications, so in a special use permit, there are requirements that they need to meet from our code. And then they might say, well, I can't quite meet that. So they are going to ask for modifications in some cases, similar to what you get in a conditional zoning, but you take that and decide how does that impact the use, your determination that use with that minor modification could still meet the standards. But to come up with other conditions that are sort of outside of it is you can't do it. 160D 1402, this is really about appeals. When something's appealed, it's called an appeal in the nature of certiorari. It's the way we have to file cases that are appealed. But the thing to pull from this section of the statute is the definition of who has standing. And I've kind of summarized it here. I didn't verbatim copy everything, but again, somebody who's got the ownership interest, somebody who suffers special damages. You could also have an incorporated or unincorporated association. Those are usually like a condo association or homeowners association that pays dues related to the property. So if they have somebody in their neighborhood that's doing something and it affects the neighbors by virtue of that, their property rights, then they have standing. And this last one's an interesting one. Local governments whose decision-making bodies has made a decision that the governing body doesn't properly believe was granted. So a city council could bring a suit, and this has happened in Raleigh, against their own Historic Resources Commission. So it's not a good position to be in. It's one of the reasons that we used to have a step in between a quasi-judicial decision like an HRC would go to the Board of Adjustment to decide whether that they had made the right decision, and then it could go up to court. But then you have two quasi-judicial bodies in the same, our Board of Adjustment and our Historic Resources Commission kind of pitted against each other. And since the statutes permit it to just go right up, then that's what we changed our ordinance to. This section of the statute also talks about what's competent evidence. This is where you find that you can't have opinion testimony on property value, increase in traffic, or other expert matters that an expert should testify on. Oh, I'm already done. So, with that, again, it's a lot of information. If I'm sure you do have questions. I was saying to Kim, I won't put her on the spot, but it sometimes is a good exercise for the chair to read what the preamble that we normally have, so you hear a reinforcement of all the things that I said. But we might not do that right now. I know I had a note. I did want to go back to our standards and ask you a few questions. There they are. Okay. Looking at these standards, what do you think are going to be the most difficult ones to deal with, and why? And I'm sorry they're small, but they're 7.
I have a quick question.
Sure.
On number 5, it lists one of the considerations for general conformity is Sustainable Economic Development Strategic Plan. And I've never seen that. I did a quick Google and couldn't find it. So I don't know. It sounds pretty formal and well-defined.
That's a good catch. We never changed these standards, even when we updated it so that the Planning and Zoning Commission would hear this. The standards stayed the same. And I'm not sure.
I want to read that plan. It sounds awesome. Sustainable.
So it was, these standards were probably adopted in 1997, and we can find it. We can find it for you. But of course, it would be the applicant sort of saying, oh, I meet the comprehensive plan, or if they do meet the sustainable, they will have found it, and you can say, oh, yeah, but you're right. You need to know what plans if somebody's going to raise that. So we'll look for that.
Well, I mean, yeah, whether or not we did a good job of updating it or maintaining it, that's a different story. It is there and sounds great. I want to read about it. Even if just because it was in 97 doesn't mean.
Yeah, we might have to go into our institutional knowledge about that one.
Dang.
Actually, our old city attorney, Bob Oast, was just here. I'll just ask him, what was that? Because he was here in 1997.
I think there was also several economic development corporations in Asheville, right? Like, wasn't there Advantage West and stuff like that, and the state changed how they did economic development?
Yeah,
Like,
but they weren't city bodies.
no, okay.
Yeah.
Random facts.
Yeah. Well, all I wanted to point out here is, we've already talked about it, but we have two standards that require expert testimony. So we have three is the value of property, and 7 is the undue traffic congestion. So that's like future traffic. And again, on the other quasi-judicial procedures, variances by the Board of Adjustment or the Historic Resources Commission, I can't think of anything that absolutely requires expert testimony. So this, makes it a little bit more.
I mean, so would that be an appraiser?
An appraiser. Or the adjacent property owners could come forward and say, I know about this use and I don't think it affects my property value, because a property owner could testify about their own property value, but they can't testify about what the neighbor's property value is.
Well,
I had one on the traffic.
Mm-hmm.
I think in other areas we have traffic thresholds, like more than 100 vehicles at peak hour. I don't know exactly how it is technically. Do we have any kind of threshold like that would trigger like a actual study, or is that tied to this? I don't.
No, I know what you're saying, but that's outside of this, because we can't say, even if our technical review committee says, well, we're not, we don't have concerns, or that doesn't trigger a traffic impact analysis, it's the applicant's burden to still sort of make that case. But as I said, because the standards have been so minimal, they can basically say, no, I don't think it will. I mean, really. And if somebody from the opposing doesn't stand up and say, oh, I think it will, and has a traffic impact stand with them, then you could continue a meeting and say, oh, somebody's saying that they have evidence contrary. But if they don't have it right then and there, it won't have an impact.
Understood.
Yeah, because the staff, again, can't testify to or provide information regarding, well, in other, the technical review committee said it was fine. Even that, it's not something you're supposed to consider. As you do with other legislative decisions, you're going to look at what the technical review committee said. But the way we used to do this, the Planning and Zoning Commission, it was like a dry run. You would have it, but it was legislative. And then none of that, the applicant might think, oh, I did well, or the neighbors think, oh, I did well. But then the council was making the quasi-judicial decision, and they were not supposed to know about or consider any of that information that happened at planning and zoning. It's very confusing. It was probably one of the reasons that the PhD case didn't go well, because again, it just was such a different process. So,
I'd like to go back to the burden of truth versus the chinchilla of evidence.
Scintilla of evidence,
Scintilla of evidence,
which is,
okay.
there is a School of Government article entitled, what is a scintilla, in your packet.
So if they present the bare minimum, basically and no one contests, then we have to approve it.
That's right.
Okay, even if we don't like it.
Well, if you don't think that that it tends to prove,
Okay.
you can cross-examine. You're permitted to ask them, and you say, well, can you tell me more about that? Can you that maybe it isn't that convincing. So you can ask them questions.
Okay, call some BS, I'm ready. Okay.
On the conditional component, I don't know enough about it, but it says here that the development of land will be in harmony, scale, bulk coverage, density, and character or neighborhood in which it's located. And then we have like buffering. And so just say it's in a residential zoning, but is now being used in a more commercial way. Is it a viable condition to think about buffering in that manner, even though it would be, I would suspect, the same zoning?
Yes,
But the buffering
yes, but-
UDO wouldn't, you know what I mean, the way you
Yes,
read the buffering.
yes, and it is one of the things that a neighbor could speak about. See, that's the hard thing. They have standing, but how else is going to speak about how this impacts the neighborhood if it's not a neighbor? So I would say you have a little bit more leeway if somebody's saying, there's not going to be a buffer, or they're not proposing a buffer. Now, staff can also provide information in the staff report to say whether they have met like buffer requirements. I think sometimes because we know it is a special use, there are enhanced standards that they already have to meet because of that. And then on top of that, they have to meet the general standards. So the statute goes into more detail about what is a condition. They often talk about like requiring a right-of-way. Sorry, that's it. All right, I'll just read it just so you've got it, because this is the full statute. Where appropriate, such conditions may include requirements that street and utility rights-of-way be dedicated to the public, and that provision be made for recreational space and facilities. Conditions and safeguards imposed under this subsection shall not include requirements for which the local government does not have authority. So they kind of give you some guidance, and then they say, like, without limitation, taxes, imposing a tax, imposing an impact fee, design elements, requiring certain design elements, because we know under the statute for single-family houses, you can't impose design requirements. But again, or other unauthorized limitations on the development or use of land.
So in the case where it would be like a residential special use, and residential to residential, because it doesn't change zoning type, right? It would
Right,
still
doesn't
be-
change,
Okay.
right. And it's probably because it's in a particular zoning district that it's a special use.
Gotcha.
So say a jail might be a use by right in a institutional zone. But if it's in a commercial zone, and I don't know that offhand, but if it's in a commercial zone, then the jail it becomes a special use.
Okay.
Yeah.
So, but in a residential setting then, because like in our design standards, we don't have residential to residential, it sounds like based on the interpretation you just read, that would be excluded from our purview as a condition.
The zoning,
A buffer,
a buffer,
yeah, like a buffer wouldn't be.
it's really something that should be raised by the applicant. So unlike conditional zonings where you start to think about, well, I'd like to see this kind of condition. It's really, so the applicant says, oh, I fit into the neighborhood and I don't have any, it's not going to have any impacts on the neighborhood. And then you could ask that question, well, what is the buffer? Or a neighbor, it should be an adjacent property owner, again, somebody really has standing, saying, I think there should be more of a buffer, because I'm going to if I don't have that buffer added, then it will impact me.
Like a group home or
It-
something.
I mean, that could be if there's a buffer, but again, it has to be brought by somebody who's, usually it's the adjacent property owner, so.
On the standing determination, is that something that the chair kind of oversees, or is staff assisting with the determination of standing and who can testify?
That's why it's a tricky one. Legally, Legally, I'm not supposed to say whether somebody has standing or not. I mean, you know what standing is based on this generally. Usually, if we're, staff might get calls ahead of time and we try to tell people this is, you're going to need to have evidence when you come. You're going to need to show this. And then the board you have to determine as best you can, how are you an interested party? And
So any of us could raise the question of whether or not the person has standing, we could say.
well, usually when they get up to speak, after the applicant has spoken, and they say, well, I want to say something, then you say, can you tell us, state your name, can you tell us how you're an interested party? And you're going to get somebody say, I don't know what I live in the neighborhood, I'm an interested party. Then you can just punt to this, I'm sorry, in this procedure, we're supposed to determine if you're going, if you have a special interest in this because you might have a special harm or you have an ownership interest. And ideally, again, somebody has an attorney, but if the person says, okay, well, if they present evidence to you and the applicant doesn't object, if you do consider that testimony and the applicant doesn't object, again, and if they are not awarded the special use permit because of it, it's not as faulty as if you didn't apply a standard at all or you use something very discretionary. It's one of the more difficult parts of this procedure.
So it seems like it's important to always affirm with the applicant that they don't object to the standing, right? Or I mean, if we say, oh yeah, you clearly have standing, but the applicant objects to that, then where do we go, from there? Do we deny the...
Well, if they object, then they should have a reason why they object, and they're supposed to be saying to that person, you don't have standing because you don't meet X, Y, and Z. And then the board does sort of have to say, well, it's true because understanding this is, this is true.
Ultimately, if no lawyers are involved, it's kind of just up to us to make that determination.
Yes, but you really do want to press the person to
Right.
try to have them somehow say why they suffer special damages.
And I guess kind of a follow-up procedural question. If somebody kind of drifts into the realm of unsubstantiated opinion or non-expert testimony, is the chair the judge to stop and say, you're presenting testimony that's not allowed in the quasi-judicial setting, or does staff?
It's the chair.
Okay.
And it's basically going back to what you would read in the preamble saying, please stick to the facts. Please tell us how the standards, you're speaking to the standards, and we can't consider opinions. You need to stick with the facts. And that usually gets people sort of on track. And there's also something, you want to try it? Okay, what time is it? 6:05. Oh. Okay, do you want to do a dry run of if you were to?
I'm going to try and read this.
Yeah,
Okay.
and she's working from the HRC one, which I've marked up to be useful for a SUP, and we'll get it right. But yeah, listen to it. When I did the training for our HRC, which they always do quasi-judicial, but we never did a big training like this, and I finally did one. And I started it out by saying, you know more than you think you know. And I said, that preamble that you hear every month, I want you to think about it because it's sort of reminding you of the process and it's reminding the people in the audience of the process. So if you're willing, want to give it a dry run?
Yeah. I'm just going to start with the remarks. So planning and zoning will act as a quasi-judicial body that is governed by the North Carolina General Statutes, the City of Asheville's Unified Development Ordinance, Buncombe County Ordinance, no.
Oh, yeah, that's because HRC is a joint city-county, sorry.
Okay. We will now begin the evidentiary hearings for special use permit on the agenda. As a quasi-judicial proceeding, the Planning and Zoning Commission is not setting policy, nor are we soliciting public opinion on the desirability of an application. Planning and Zoning Commission hears and considers evidence presented and applies the standards set forth in blah, 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 blah.
Yeah.
Planning and Zoning Commission must make its decision upon competent material and substantial evidence to determine the facts of the hearing. Planning and Zoning Commission will use judgment and discretion to apply the standards contained in the relevant guidelines to the facts. The commissioners, in voting for an item, will not have a fixed opinion not susceptible to change, have a conflict of interest, have engaged in ex parte communication regarding the application. Yeah.
Okay, and the way we used to do this, we will put the standards on the screen so everybody can see them.
Yeah, and then the speaking part. This meeting is open to the public, but participation is limited to interested parties who wish to provide comment or testimony regarding the proposal.
And that, yeah, and that's the part where I say it doesn't sound so legalistic to say it's limited to people who have standing. So we always try to say interested parties and then, yeah.
Yeah. If you will be speaking as a witness, please focus on the facts and how they relate to the relevant special use standards and guidelines, not personal preference or opinion.
Cross out guidelines. That's from HRC. And I will be fixing this for you.
Okay.
Now, there should be on the back about the swearing in.
Okay. Witnesses must swear or affirm their testimony. At this time, I will administer the oath for all individuals who intend to provide witness testimony.
And I guess we don't have the oath there, but I will write it down for you.
Do you swear
Or affirm.
or affirm? Yes.
You've watched enough TV to know that, to know the oath by heart.
Yeah.
And again, staff, because if you're not used to this, if you're going to be speaking, Will presenting, Clay presenting, you'll be standing up and same thing. There have been cases that have been lost because staff did not swear in, and it was, not here, but yeah.
So when do I swear in the staff, or is that all with the?
They stand up at the same time because they're going to be speaking. So
Okay.
anybody who's speaking, and yeah, so that's,
Okay.
yeah.
Yeah.
And we can work on it if there's things as you read the materials, and there are a lot of them, and you think, oh, I think I could explain that better based on what you've read, then we can work on it.
So being quasi-judicial, who's our quasi-bailiff? Clay?
I could see that.
Hear ye, hear ye. You can write that in if you want to. It's the Honorable Chair Levi that's about to speak. Yeah. I have noticed HRC likes to pound that gavel a lot more, so you'll get louder on the quasi-judicial procedures. and this is, I think it's in there, it's probably not going to happen, but every once in a while you'll get a quasi-judicial process. There's a lot of participants. And even though they don't have standing, they get up to speak and they say the same thing over and over. And so there is something that allows the chair to say, can you please just stick to new facts? We've already heard facts. But unlike legislative, where you kind of say, you've got 2 minutes and you've got this, you have to give the parties opportunity to be heard. But you don't have to continue to listen to repetitive evidence. You don't, if everybody's going to say the same thing. It's happened in an HRC one before, and they had an attorney, but he had organized the neighbors to speak, and he established that they had standing. So the certain ones right around this proposal, he established they had standing, but then there were about 6 of them, and they all got up and said their same thing, and so.
There's not a time limit, you're saying?
No. Mm. I mean, they can't continue and just keep saying the same arguments over and over, but as long as they've been heard. But they shouldn't feel like, okay, you've got 2 minutes to make your case. You can't do that.
But I gotta let them say the same thing over and over. I gotta let them say the same thing over and over.
No, you can limit that at some point. There's something in there about.
Not in a legislative.
In a legislative, you can say that you're speaking, that thing we say, if you're speaking for yourself, you have 3 minutes. If you're speaking for a group, you have 10 minutes.
Yeah.
So you can limit it. And when you have a really big hearing, that helps to be able to limit it. But in this one, if you have, for some reason, a lot of people that can somehow establish that they can be opponents, then you pretty much need to let them speak. But at some point, if they keep saying the same, I also saw that accident. I also see the accidents happen every day. And another, I saw this too. It's like, okay, we got that. But you want enough evidence, I guess, to say, well, that's a lot of evidence on that. And again, I know it's a lot of information. We have, and you haven't had time to digest anything that I just put in the folder. But if you have questions as we go along, before the hearing that where we'll be hearing the special use permit about the procedure and process, you can let Will know, and then I can, let you know something that you might need to clarify. But it's sort of hard to anticipate how it's going to go. And just remember that just because it's on an agenda, it's only what happens at the hearing that you're supposed to be thinking about and hearing. I don't think it will happen here because the standards are broad, but it's happened sometimes at Historic Resources Commission. They're on their phone and somebody saw like a design in some other neighborhood and then mention, well, sometimes this, a design like this happens. And then I, as the attorney, have to say, you need to send that so that everybody can see it, and if it's going to be part of the determination, everybody has to be on the same page. So that's why you can't have one commissioner who has a fixed opinion or heard something, if you think it's going to sway your opinion at all, you need to disclose it to the rest of the commission. So everybody's using the same information. And I can't think, the phone, and there was one, but that was an HRC where it was a realtor who knew that the applicant had said, well, they said that they didn't know they were in a historic district because they just bought the property, but because she was a realtor, she's like, I know realtors have to disclose that. So she looked up the MLS and she started to question them saying, well, the MLS says, and I'm like, can you share that MLS with everybody then? So, yeah. So you just try to pay attention to what's happening only in the before you, the evidence before you. Okay.
I appreciate your presentation.
You're welcome. It is a lot. It is a lot. I think you'll find the materials really helpful. We wish you had time for like a school of government because they do little exercises, and I was reviewing one of theirs, and I'm like, wow, I wish I could do this and give you little quizzes, but it's their full-time jobs. Yeah. And I think there are trainings that we're, working on and for other processes. So I hope it's been helpful. And again, if you have any questions between now and whenever we hear this SUP, let us know.
Thank
Okay,
you.
thanks.
While you're all here, I'd just love to put in a plug for the training that's coming May 1st. The School of Government's going to be putting on. It's all about being a recommending or a legislative body, being a planning commission. And it's really a great opportunity for us to have this coming right now while we've realized the need and the desire for more training and some newer members. School of Government's very good at it, and it's a great opportunity for us. So we'll be sending out more info, but I would encourage everybody to make time for that if you can.
And it's in Asheville? or-
It is. It'll be at Biltmore Park, at Western Carolina campus.
Just barely in the city.
Yeah.
Okay.
Super cool.
Any further questions? No? Okay, motion to adjourn.